Okay, good afternoon. Welcome to the last seminar of our series on, that is the Nathanson Centre series on legal philosophy between state and transnationalism, which is a collaboration between Osgoode Hall Law School and the Department of Philosophy here at York University and is funded by the Nathanson Centre. Today we're fortunate to have with us our 2013 Emet lecturer, that is Professor Antony Duff. Just to repeat what I said yesterday, no, it's just going to be a one-line. He's the Russell M. and Elizabeth M. Bennett Chair in Excellence at the University of Minnesota Law School, and he's also a Professor Emeritus in the Department of Philosophy at the University of Stirling. As has now become customary in the context of the Emet lecture, we have the lecture on the Thursday, and the following day, the Friday, which is today, we have a seminar to discuss the lecture more in depth. So we're assuming that you were there yesterday or you managed to get hold of the paper. And the way we're functioning is that we're going to have two commentators, namely myself and my colleague, Michael Giudice from the Department of Philosophy. We're going to introduce the session by responding to the lecture. And then we're going to allow Professor Duff a few minutes to try to respond to our unrebuttable assertions. And I would then open the session to question and answer from the audience. So my colleague Mike Giudice wanted to make sure that he would start today so that he would all say the good things, have great comments, and leave me with whatever is left to say. So Mike, the floor is yours.
I thought I was supposed to set up your criticism so that when you came around to make them after, they'd have such greater force.
Should I just withdraw it?
Okay, thank you, François. I share François' enthusiasm and excitement in having Professor Duff with us, whose work I started reading as soon as I started reading philosophy some years ago. I was hugely impressed and influenced by just the sophistication with which philosophy can be brought to bear on questions of the criminal law, and especially trials and punishment. So in a sense got the unenviable task of trying to figure out issues and criticisms for a body of work. Am I not close enough?
I'm just saying for the crowd.
Oh,
the microphone does not amplify your voice.
Okay. So I think I'd like to begin just by noting how far too many established legal theorists find it all too easy to suppose or presume that contexts of transitional or transnational or international law raise no new or interesting questions or issues for theories of law, which have been developed on the basis of reflection about law in a stable modern state. Too often, I think such theorists tend to suppose that state law and its associated practices of trial and punishment are the primary example of law. And from reflection about law in its context or home in the nation state, we can all learn everything we need to know about the nature of law and its associated practices of punishment in the criminal law. Such theorists also tend to suggest that while transitional or transnational or international contexts raise difficult questions and new issues, they only raise questions in a sense at the margins or the borders of the discipline of legal theory, whose main focus is to explain state law. I think in such contexts, according to this view, we simply wait for the fog of war to lift. And then we can get back to theorizing law in its stable, steady context. Or at least so that particular view goes. Now, as someone who works on such borders of the discipline of legal theory, I think it's important to acknowledge that Professor Duff's recent work in criminal law theory, both manifested in the lecture yesterday, but also in much of his other recent writing, is an important exception to this general trend. His sophisticated account of the criminal trial, first developed in the context of the state, I think has much to show when extended and applied to transitional and international contexts, often in contexts where conditions are fairly unstable. So it's in that spirit of extension and application of his account of the trial that I'd like to explore a bit in my comments. So the criminal trial and its theory plays a crucial role in the practice and justification of criminal law. In practice, the criminal trial provides the bridge or connection between, on the one hand, in a sense, the failure of the criminal law to secure the obedience or guidance of some of its subjects to particular laws, and on the other hand, any punishment which is deemed or found to be merited, warranted. But on Professor Duff's account, the role and value of the criminal trial is, of course, not simply nor even mainly instrumental. It represents part of the state's duty to treat its citizens as rational agents with respect and autonomy by calling them to answer as rational agents, as fellow citizens, for their wrongdoing. So a distinctive feature of criminal offenses, such as murder and sexual assault, which is not shared by civil offenses, such as various forms of nuisance, is that the commission of criminal offenses is of concern not just to victims or those personally related to the victim or wrongdoer, but are of concern to society as a whole. So crimes are, in this sense, crimes or harms against the state or people understood as a collective. So the role of society, or more accurately, the political community, is crucial on Professor Duff's account. For if crime represents conduct which concerns a community, then it's essentially the community's right and obligation to address the wrongdoer and call them to answer. As members of the political community, subjects have the right to be respected as free and equal rational agents, and again, as fellow citizens. If some subjects have been properly accused of wrongdoing, then they have the right to a process which provides them with the opportunity to hear and respond to those charges. So courts, juries, trials on this view are simply the institutional means by which the accused wrongdoer and the political community engage in the enterprise of rational communication. Now, the political community also serves a kind of exclusionary role here. It's only the political community of the wrongdoer which has a duty and the right to call a wrongdoer to answer. Other institutions, which are not part of the political community, simply have no business or standing to call offenders to answer. Now, a further note about the role of political community. A wrongdoer is called to answer to their political community because they have been accused of breaking the political community's laws. So as Professor Duff explains, one of the aims or values of criminal trials is reassertion of the authority of the community's laws, reassertion of its authority over the accused and its authority over the political community itself. In other words, such laws then are to be understood as rules and norms which claim authority and so treat subjects as rational agents, and they're directed towards the common good of the political community as a collective. They are laws which exist at the time of offense. This is, I think, what it means to say that the trial and the courts reassert the laws and their authority, and can be said to have a morally legitimate claim on the obedience of subjects. Now, law's moral claims over its subjects is, I think, one of the important necessary connections between law and morality, which, depending on your philosophical view, philosophers of law are either often keen to identify or deny. But it seems to me to highlight an important role for Professor Duff's account of the trial. That's to say that if a political community, through its institutions of criminal justice, can't demonstrate the moral legitimacy of its laws through calling its wrongdoers to account in ways which treat them as autonomous, rational agents, then the moral legitimacy of its laws is open to serious doubt. And I think this last part unearths two preconditions for a morally legitimate trial. That's to say, conditions which, if unmet, bar a trial from being morally legitimate or at least raise serious obstacles. The first precondition is that there has to be a continuity of law from the time of the offense to the time of the trial, such that alleged wrongdoers at trial are called to answer for breaking laws which existed at the time of their alleged offense. If the law has changed, then trials risk not treating alleged wrongdoers as rational agents, in that they risk calling them to answer for breaking possibly retroactive laws. The second precondition is that the laws must have a morally legitimate claim over its subjects. Now, this is only a precondition, as it's possible for wrongdoers to have broken morally legitimate laws, and yet if their trial is improperly conducted, the trial itself might not be morally legitimate, despite the legitimacy of the laws themselves. So this is necessarily a rough and ready summary of Professor Duff's account as it's been developed in the context of a stable modern state. But I think hopefully it's enough to raise a few questions when extended and applied to transitional international contexts. I want to move to those contexts. So one of the issues facing courts and tribunals in transitional international cases is to identify the relevant political community which has the standing to call wrongdoers to answer. So in international cases of criminal law, where there exist international institutions which often claim universal jurisdiction, so both international courts and tribunals, but also some state courts claim and have claimed universal jurisdiction. Some suppose that the relevant community here is humanity at large. So crimes against humanity, it's thought, requires such a community. Yet as Duff notes, such appeals are problematic. While we might be able to speak of a moral community of humanity, there clearly isn't any political community of humanity with a thick set of political institutions that make political participation for all humanity possible. This I take it to be part of an underlying assumption here is that political community has some kind of connection to democratic values or a democratic structure. Transitional contexts raise a similar but slightly different difficulty. In such contexts, it might be quite accurate to speak of the transition of political communities, for often the transition is between the laws and institutions of a regime of one nature to the laws and institutions of a regime of a different nature. So in such cases, we might say that the transition here is a transition between A to B, is essentially a transition between political community A to political community B. Now, these observations, I think, raise a particular worry for trials which address or are meant to address wrongdoing which might have occurred under conditions where there was no established political community, such as international cases, or in cases where the relevant political community has changed or perhaps been replaced with another. In such instances, it becomes difficult to see how the institutions of criminal justice could meaningfully serve as the representatives of an existing or continuous political community which has standing to call wrongdoers to answer for wrongs that happened in the past. A second worry, I think, follows from this first one. Not only must we identify the relevant political community that has standing to call wrongdoers to answer in transitional and international cases, but I think we must also identify the relevant law. So for example, in transitional cases, not only might it be important to acknowledge that the political community has changed, but perhaps and quite likely the laws have changed as well. So courts will then need to worry about retroactive dimensions to their activities, which certainly offend against principles of the rule of law, principles of respect and autonomy. Along these lines, we might also need to distinguish between trials for officials and trials for citizens. So to take officials first, while high-ranking officials in unjust regimes, state leaders, for example, of regimes that are overturned might be properly held accountable under international criminal law for their actions, right, assuming that we can settle the question of an international political community, which I think we might be able to do if we restrict the international political community to that composed of state leaders, but not necessarily all of their citizens or subjects. I think we'd still have to face questions about how to address citizens of those unjust regimes who might be called to answer for actions which were at the time legal or demanded by their governments. In such cases, their actions, citizens' actions, might not have been deviant, but required by law, and so very different from the actions of wrongdoers in stable, just states. Now here I think the contrast with stable state contexts is quite clear. In stable state contexts, attributions of criminal liability presume deviance from the political community's criminal law. Whereas I think in transitional situations, that's not always the case. So the worry here is that in the application and extension of the argument, there are conditions in transitional and international cases which might give rise to relevant differences in how the trial might operate or whether it might be legitimate. Now, I don't think these observations necessarily undermine any of Professor Duff's move to extend and apply his account of the criminal trial to transitional and international contexts, but I do think they raise some further issues about the preconditions for the legitimacy of trials in such contexts. Now, whether these issues might ultimately push us away from adopting or resorting to trials to address situations of conflict or transition, whether they move us away from trials to, say, alternative forms of dispute resolution, I'm not sure, but I think François wants to take up those particular questions, so that's where I'm going to finish.
All right, thank you, Mike. So I'm going to do a bit like Mike and try to recap a bit Anthony's lecture, because I actually see some people in the room who are not at the lecture and whom we failed to sign the paper, so they will be swimming here, but they're very intelligent, so I'm sure they'll be able to catch up after what I have to say. So yesterday in his Emet lecture, Antony considered the applicability of his understanding of the value of normal domestic trials, which are normatively characterized as processes to which citizens are called to account by their polity for the perpetration of public wrongs, in cases of transition, as Mike said, as well as cases of international criminal justice, with for the latter a focus on the International Criminal Court for intrastate crimes against humanity. That's what he looks at. So I first want to focus on transitional justice and try to point out some tensions in Antony's argument. While I'll try not to echo too much the comments that were made yesterday, as well as Mike's comments, but there might be some overlap. That's inevitable. It's the same lecture that we're talking about. Now, for Antony, criminal trials are normally, as well as essentially valuable as means of calling offenders to account for public wrongs that they have presumably committed. That is the mark of the value of the trial. That's a mark of the kind of understanding of the trial that he wants to put forward. On one hand, trial assert and demonstrate the law's authority to define, to enforce the polity's central values, that is, those values whose violation constitute public wrongs. Trials also assert the law's authority over defendants as people who are bound by the values that the law declares and bound to their fellow citizens by their civic obligations, bound, that is, to answer to them through the process of the trial for their alleged public wrongs. Indeed, trials assert the law's authority over all citizens by declaring that it is the proper forum to address public wrongdoing, as opposed to other potentially violent and uncontrolled responses. Furthermore, Antony tells us trials are normally valuable in that the calling to account that they foster recognizes victims of crimes by recognizing the wrongs that were done to them as wrongs that are the polity's business. And finally, trials are valuable in that they do justice to offenders themselves by recognizing their status as responsible members of the political community. Now, in this sense, Antony tells us trials really reaffirm political community. They reaffirm the values by which a political community defines itself and the place of both victims and offenders within that community. So it facilitates a formal or symbolic kind of civic reconciliation between offenders and victims, between offenders and citizens writ large, and even victims and the community. So it's easy to see why Antony thinks that criminal trials may have an important role to play in cases of so-called transition from civil conflicts, in which widespread and serious wrongs were committed to functional polities that can justly serve the goods of all their members. They can reassert the authority of law, they can affirm the standing as members of the polity of those involved in public wrongdoing, and thus they can facilitate the reconstruction of civic trust, as well as a limited symbolic reconciliation of citizens in a way that makes justice under the rule of law once again possible. Now on to the criticism. One first thing to point out, I think, is that it may be that trials may not always be able to play this kind of valuable role in transitions. So suppose, for example, that some central parties to a civil war will only agree to lay down their arms if they are offered an amnesty allowing them to escape criminal prosecution. And suppose further that such amnesty will save many thousands of innocent people's lives, and that any prospect of criminal trials would threaten this kind of new delicate equilibrium that is reached by the amnesty. Should we still insist on criminal trials in such cases? If not, then Antony may need to tell us something about the conditions in which criminal trials should be insisted upon as means of social reconciliation. To be sure, all parties putting down their arms in the case of an amnesty may agree to accept the law's authority from that point onwards, insofar as backward-looking considerations are officially suspended. Such state of affair may not be ideal, but it may be optimal in the circumstances. Now, no doubt, Antony recognizes that criminal trials are only one tool amongst many for achieving conditions of justice post-conflict. Yet it seems to me the case of amnesties call for a more explicit assessment of the weight of the intrinsic value of trials, as Antony understands them, which may perhaps vary between, say, different kinds of wrongs in the face of conflicting values. Indeed, this assessment seems all the more called for in light of the fact that trials typically require significant resources that can then not be allocated to other parts of a reconciliation and reconstruction process. And as Antony points out, given the fact that trials tend to make very heavy demands on participants. Now, to make this point even sharper, we can reflect on Antony's own acknowledgement of the central tension of transitional justice as the fact that identifications, arrests, prosecutions, convictions, and punishments that are typical hallmarks of criminal trials can obstruct rather than assist transitions to just and functioning polities. Why might they create such obstruction, one may ask? Well, I take the point to be that they may generate a kind of resentment that leads to social instability, inimical to long-term peace and justice. Antony's seeming willingness to untether trials from punishment may help here, admittedly, in that arrest and conviction may be perceived as softer or less antagonistic than punishment, and they may generate less resentment. Of course, I think this is itself a questionable move, as was pointed out yesterday, as it may turn out that it may turn trials into more into not so much truth commissions, which Antony mentions in the paper in the lecture, but into public inquiries in which calls to account are made, yet formal sanctions, which are typical of the criminal process, are conspicuously absent. I have a colleague here at Osgoode, Gus Van Harten, who has argued that public inquiries and actually criminal trials ought to be mutually exclusive, given their similarities. So, for example, the fact that they both have to do with calling to account, yet that they also fundamentally distinct kind of processes, partly due to the fact that formal sanctions are attached to the criminal context and not to public inquiries. So there might be something to this that maybe we want to discuss further on. I just wanted to put it on the table. The bigger point, though, I think, is that thoroughgoing identifications, arrests, prosecution, and convictions of wrongdoers may generate deep resentment that stands in the way of communal harmony. And if, as Antony posits, trials can only hope to achieve a very limited form of reconciliation, which by its very nature is highly formalistic, ritualistic, and explicitly lacks personal and emotional dimensions, then we may wonder whether trial's simplicity may not, just like punishment, risk putting oil on dormant fires and fuel destabilizing resentment. Now, where does this leave us? Well, I don't exactly know, but perhaps it points to the need for carefully selected prosecution, namely those that will maximize reconciliation while minimally risking backlash. Or perhaps it points to a case to be made in the context of transitions for processes, perhaps even trials, that are more attuned to personal and emotional dimensions, more attuned to the neighborliness aspect of communities, which Antony tries to steer us away from. Can liberal democracy, in other words, really hope to emerge from strictly liberal processes that respect individual privacy and freedom through and through? The question seems at least worth asking. Another yet, I think, related problem is what I call the problem of partiality. Calls to account and convictions for public wrongs, often, although perhaps not necessarily tied to sanctions, raise serious questions of justice. I mean, the process can go wrong at many points, right? When the process of identifying and arresting suspects, of determining who is culpable, determining how much culpability they have, and often with respect to the determination of the degree and the method of punishment and the enforcement. And errors at this stage can result in inflicting gross injustice on relevantly innocent people. So much depends on process. And one may think here that two types of impartiality are required. Judge, jury, and other relevant officials must have nothing to gain from the trial's outcome, and they must have no prejudices about the plaintiffs. Some also think that legitimate authority is a prerequisite of justified punishment, either because legitimate authorities are more likely to be impartial, or because something intrinsic about them makes them the proper agents of punishment. So given this, it seems clear that permitting those who happen to come out on top of, say, a civil conflict to carry out criminal trials invites injustice. Victor's justice, that is, will always be tainted, however noble our aspirations. In fact, as well as being conducive to injustice, Victor's justice is inherently bad for the prospects of peace. Once again, even if, against expectations, those who come out on top impartially try wrongdoers, well, those who end up on the losing side will almost certainly resent additional impositions on their vulnerability. They're unlikely to believe that the trials are just, either because they believe that their cause in the civil conflict was just, or because they doubt the implementation of justice by those who came out on top, on the reasonable assumption that Victor's justice is always, or at least almost always, corrupt. Antony's response here might be that his account assumes reasonably legitimate and just trials, asserting or reasserting legitimate and just legal norms, embodying genuine public wrongs. However, I wonder if this move is really available to him, since he also speaks of trials as one kind of process that can help move a society from conditions of conflict or oppression to those of a functional, legitimate, and just polity. So I wonder if assuming that the process is reasonably just from the outset does not undercut Antony's contention that trials can themselves be partly constitutive of the move from injustice to justice. Antony's constant emphasis on trials as means of reasserting the rule of law and restoring civic trust and public values might give the illusion that there is a past and legitimate order to which courts may easily look back to in order to frame their processes and the norms they apply in just and legitimate ways. However, this will often not be the case, especially since deep-rooted social conflicts and protracted periods of authoritarian oppression often themselves shape and change the values of communities in ways that can prevent equating post-conflict or post-oppression communities and their values with those of a pre-conflict or pre-oppression era. Now, if I am right that the prospect of procedural and perhaps even substantive partiality is particularly salient in transitions, and that although trials may be means of addressing it, they will also likely falter significantly along the way. So then we may have an additional argument, if that is true, to support Antony's intuition, which he talked to us about yesterday, that procedural rights, such as the right to silence, should be afforded to defendants in such circumstances, and quite forcefully so. Because insofar as the legitimate authority of the institutions trying individuals is uncertain, and in a process, as it were, of being asserted, well, then we may think that there is all the more reason for defendants to have means of opposing what they perceive as illegitimate. Now, shifting briefly to international criminal justice, we may also think that the principle of complementarity that Antony advocates in respect of the jurisdiction of the International Criminal Court cannot be as straightforwardly applied as he thinks it may be. To be sure, everything seems to turn on what is meant by genuinely in the criterion that the state of so-called primary jurisdiction be unwilling or unable genuinely to carry out the investigation or prosecution of crimes. That is, state institutions may well be willing and able to investigate and prosecute, but what if they're likely to do so in a partial way? As I suggested, will often be inevitable in cases of transition. Now, this kind of worry leads some to think that legitimate global institutions is really where we should look for prosecutions in such cases, and that the presumption ought to be in their favor. Genuinely, that is, ought to carry a highly normative meaning of just and legitimate, which, as we've seen, may be hard to achieve, at least in the early stages of a transition process. Now, of course, we bump here into difficult questions about the comparative legitimacy of global institutions themselves. I won't say much about this here, except to focus on one issue that Antony himself raises, and that is that what is the legitimate polity or political community to which those involved in international trials belong? They belong as defendants, as victims, or as judges. Antony argues that the International Criminal Court, when it calls a defendant to answer for a charge of crime against humanity, speaks in the name of the community of nations, right, on behalf of the citizens of the nation in which the crime was committed, citizens whose own state apparatus, we're told, has failed them, given the complementarity principle. And here, as was pointed out in yesterday's question period, we have a potential problem of paternalism, of the community of nation imposing values and seeking to act on behalf of citizens of democratic, non-egalitarian polities. I actually wondered yesterday if this problem is really as difficult as it may seem in the case of crimes against humanity, because in the case of such crimes, we're actually dealing with grave violations of human rights, which one may think trump any claim to individual or collective autonomy, self-determination, or sovereignty on the part of individual or collective perpetrators. But I won't say more about this here. The issue might come back in discussion since it was raised so eloquently, much more than I can do yesterday. What I want to emphasize, and that's going to be my last point, is the concern that I have with Antony's idea of a community of nations. Right? What is that? Antony actually doesn't tell us much about it, but much seems to hang on its plausibility. Now the idea seems to imply that nations are entities that can enter into communal relationships, just like individuals within the nation enter in communal relationship, thus giving rise to the nation. And that nations can do so, and can enter in these relationships over and beyond the individuals that constitute them doing so. Now here we hear echoes of theorists like David Miller, who do think that nations can be moral agents, that can enter into such relationships in their own right. But on most, and one might think on the most plausible accounts of group agency, loose groupings like nations that are primarily defined in terms of history, of culture, and traditions are not sufficiently organized to count as agents. States as complex organized groups with intricate decision-making procedures and internal normative safeguards against rational inconsistencies over time might be agents. But as Antony points out, states and nations are quite likely different kinds of beasts. So does Antony think that nations are agents, irreducible in some form to their individual members? If not, then isn't a community of nations really only a community of individuals, which, if it is extended to the community of all nations, might actually fold into humanity as a whole, which is a position that Antony seems to want to resist. Now, of course, there remains here the possibility of nation-less individuals, which would forestall this kind of move. But I wonder if the resulting aggregate of individuals within nations is really all that Antony has in mind when he speaks of a community of nations. I guess what I want to know is what binds this community? What makes it a distinctive political community, which, to be sure, is different from a community of states that negotiate treaties, share membership in international organizations, and so on and so forth. I also have other thoughts, but I've spoken for 5 minutes more than I was supposed to speak, so I'm going to stop myself here and let Antony respond.
Right, how long do I have? An hour?
As long as you can. I would say 5-10 minutes a day.
Yeah, well, thank you both very much for some very helpful comments. What to say? I should say, thinking about the paper, I'm quite confident of section 2 on domestic trials. I'm happy with the story there, more or less happy. I'm less sure about section 3 on transitional justice, and even less sure about section 4 on international. I get less certain if the paper goes on, as is evident from the paper and will be evident from my comments here. Let me take the comments in reverse order and start with François. And on the issues in transitional justice, I'm trying to say, yes, of course, you're right. There are all these obstacles to trials serving any useful role. There are obstacles to them being possible at all, and to them serving a useful role if they are possible. And what I wanted to say, and perhaps didn't make it clear enough, even to myself, was that here's a particular role that trials can, if properly conducted, play. A role of addressing past wrongs seriously as wrongs for which people are now called to account to their fellows. And that's an important kind of enterprise which trials perform, which is worth performing, which is value in the context of transition from oppression to peace, if it can be done. One question is, how important is it? How far should we try and insist, yes, we must have trials, even if this is dangerous? Or how far do you say, look, if trials are going to cause trouble, then maybe you don't even bother going out. And I'm not sure how much weight to attach to trials, but there is a value there which trials have other than as means to punishment. That's the key point. So trials have value not just to figure out who gets punished, but in themselves there's value as according to account. You point out rightly that all kinds of conditions must be met before trials are possible, all kinds of ways they can go wrong or not produce the inherent goods they're meant to produce. And I agree with all of that. But still, it seems to me trials as an enterprise in building or rebuilding, I'll come back to the rebuilding bit in a minute, can have that kind of value as part of a transition from oppression towards justice. So I didn't want to say, and the thought is then that if you ask what transition should we aspire to, if we are the members of the newly emerging peaceful polity, should we try just to forget the past wrongs? Or should we, if we can, address them somehow, and if so, how? And my opinion is we should think, well, if we can address them, we should, and here's a way to address them which takes them seriously, but doesn't look to punishment as the only possible outcome. And that's the most I'm claiming for the process. So I'll come back to Michael's concerns in a moment. Actually, no, let me deal with those now. I'm going to talk about the international context later on. So Michael raises some deeper worries about the conceptual possibility of trials as I portray them in the context of transition from conflict to peace and justice. Some problems, for instance, the one about retroactive laws, are problems not just for my account, but for any account of trials in that kind of context. So it's not problems, but not just for me. Others are problems for my account in particular. And here's, perhaps I'll show you this by way of background too. Part of the problem for my account, as Michael points out, is the reliance I place on community as being the forum within which trials take place, and the grounding of trials, normative authority. They're grounded in a political community and its values. There are other starting points for theorizing trials in general and trials in transitional and international law in particular. So I say, look, forget community, start off with the demand of justice. Justice demands that wrongdoers get punished, they're called to account. That's an impersonal demand addressed to all beings. The question is, again, who can best fulfill that demand? Sometimes local states, sometimes international courts, sometimes other bodies can do it. But the starting point on that kind of theoretical view is an impersonal demand of justice that people be punished or called to account. If you start there, you avoid some of the worries which Michael raised from my account. But I want to say, no, that's not where you start from. But you start always with wrongdoers being called to account by those with the standing to do so. I was going to ask, I think we always have to ask, who has the right standing to call these people to account? To whom do they answer? There must always then be, as our starting point, a notion of a community to which the wrongdoers belong and by whom they're called to account. And that seems to be a general point about the notion of responsibility. It's always to someone with the standing to hold you responsible. We'll think about, well, to whom do I answer? And it seems in the context of law, the answer must be to this specifiable political community. Because law itself is a political institution and thus depends upon a political structure. So the answer to the to whom question would always be to this identifiable community, political community, whose law you're charged with violating and to whom you answer. If that's the right starting point, we must always build in from the ground floor up the notion of the to whom I answer. And if the to whom I answer is always going to be, in the case of law, a political community, we then face issues in the international context. What is this community? And in the context of transitional justice, well, is there a community of the right kind which runs through from offence through to trial, which is one of Michael's concerns. So Michael's worried, in part, one of his concerns, right, is about the continuity of community and of law. If I'm to be tried now for what I literally did in the pre-reconstructive situation in the conflict, then on my account there must be a continuing community. I offended as a member of that polity, and that polity, which is still here, is what calls me to account. But Michael says maybe what's changed is precisely the polity itself. And secondly, if I'm called to answer for wrongs I committed, the court must be able to say, look, you're now called to account for conduct which was, when you committed it, a wrong by laws which existed then and exist now. And that's the second issue about continuity of political community and of law. And this ties in too with François' concern about talk of restoring, or is it Michael's concern? No, it's François, about restoring, reconstructing as if there is a past community which was fine, and now it's okay, it went through some problems, and now we rebuild it, restore it, we reconcile. And maybe that's just not how things were. Maybe there wasn't such a community. What we're doing now is starting to build, not to rebuild. Now, I think that any talk of transitional justice, it seems to me, does presuppose some notion of a continuing community. We look back on the past, and perhaps we look back through the eyes of aspiration rather than fact. We see the past through the light of the community it should have been but didn't succeed in being. We see the injustice committed, we see the oppression committed, we see conflict, which was, as we now see it, an eternal conflict, a conflict within a polity. So we have a notion of what the polity indeed should have been in aspiration, but wasn't in fact. And that's what's now being, in this odd sense, rebuilt. We're now building what should have, which existed in aspiration but didn't exist in fact. So I think there is a notion here of continuity where the past takes on, is seen now in aspirational terms rather than descriptive terms. So I think I can get somewhere with that, saying there was then a community to which both sides belonged and failed to take seriously as a political community. So it didn't exist in their behaviour, but it still existed as we now see it in aspiration. I think there's some sense to that, which gives you a notion of community. As to the continuity of law, which again, I say the problem is not just from my account, but any account, I'm tempted by the following thought, which may or may not stick, but we'll try it and see. On my kind of law, criminal law in its core substantive dimensions does not prohibit conduct. It takes for granted these things are wrongs. Murder, rape, assault, torture, and so on is wrongs. It doesn't make them wrong. Rather, law declares that these wrongs are ones to get called to account for by the formal court. So law, as I understand it, takes for granted that these things are wrongs. Its role is to declare that some of these wrongs are public wrongs, i.e. wrongs which are going to be called to account for in a criminal court. So the worry about retroactivity is not that the courts are now, as it were, making wrong what wasn't wrong at the time. It's always wrong. Rather, the courts are telling you now, which you weren't told at the time, you'll be called to account for this in a court. And I'm tempted, I think, still by this kind of move, that given the nature of the wrongs at stake here, these weren't kind of borderline cases of wrong. They weren't, is it just slightly devious practice or is it a wrong? No, these are cases of murder and torture and so on. The court could properly say, look, there's no room to doubt that those were wrongs and were evidently wrongs at the time, even if they were legal. And it's not unreasonable now, given the nature of the wrongs, you're now called to account for them, even if you weren't given warning, you would be called to account. It can't be a surprise to, as it were, that you're called to account now. So I'm not sure I'm definitely that worried by that if the crimes which the trial's now held are defined carefully enough, the fact that they weren't defined as criminal at the time, if that's true, it seems to me not to be a serious obstacle. And I stopped. But let me say one more thing. About the international case. I guess I'm happy to go along with, to be a lot, I like with David Miller on this. Okay. You sound surprised. No, look.
He's very provocative, that's for sure.
That's a bad thing?
No, I'm not sure he's right.
Yeah. No, but look, it seems to me that you can't portray humanity consisting of all individuals as a political community. That doesn't begin to make sense. That's why I looked to the Community of Nations as a possibility. I agree with you, there is an issue about whether nations can be agents. I'm not sure why I shouldn't try to say that nations are agents through the states, which are their institutional forms. So states are the agents, but they are agents, should be acting for the nations whose states they are, if you like. I think that you have the nation there as the normative underpinning.
But it's just because in your account you tried to disconnect them. You say in certain situations the state is going to not reflect the nation in terms of what it does. It can be an accomplice in wrongdoing against the nation.
Yeah, but when states function as they should, then they are the agents of the nations whose states they are.
Sure. Okay.
When things go wrong, they are. So I can accept your point that nations aren't themselves agents, but still have a notion of the community of nations that's doing some work.
Right.
But I'll stop there. I want to hear what others have to say. Thank you both for the comments. There's more to think about.
Professor Scarafa, we'll have to circulate the microphone because it's being recorded. So.
Thanks for the paper. It's a pleasure to read. I had a question. I'm very sympathetic to this idea that an important role of the trial is, hopefully I'm characterizing this correctly, important role of the trial is the assertion of political community by the members and representatives of that community. And I can see from that thought, thinking about trials in that way, you might think that trials at the level of the International Criminal Court, they don't look like the same sort of thing. They're not performing the same sort of role. It doesn't look like that's an assertion. The International Criminal Court doesn't seem to be asserting political community by the members and representatives of that community because of the complementarity principle. Because what they're doing here is they're trying to protect norms of a community, of a different community. But then I thought, so your idea is that, look, the ICC is, this is to quote, it just acts as a kind of proxy for the national courts in which the perpetrators should be called to account. It cannot claim, as national courts should claim, to be acting or speaking in the voice of the citizens to whom the perpetrators should answer. And so the idea is that the ICC, it's a kind of imperfect, it's not even an approximation, it must be doing something different because it's not an assertion by the relevant political community of the political community of that political community. But then I was wondering, well, if that's the case, if it's just this proxy, why does the International Criminal Court have a limited brief? Why, if it's just a proxy for a forum that's an alternative forum to police the norms of this other community, well, why is it a limited brief to just crimes against humanity? Why that limited brief? Why can't we prosecute just anything at that level? And so then I thought, well, no, maybe the original idea was right. Maybe here the International Criminal Court is an assertion of political community by this higher level political community to police certain norms that are typically discharged at the level of smaller political communities. So I guess maybe to make the question a little bit more tractable, why the limited brief? Given your construction, your account of what the ICC is doing, it's this kind of proxy. Well, then how do we explain the limited brief of the International Criminal Court? And then I have this alternative that, well, maybe it is doing the same thing, but it's just doing it at a higher level, asserting political community at a higher level.
And your high-level community is?
The international community. The community of humanity, the community of a community of humanity where there are certain thinner sets of norms that this community polices that answer to that roughly correspond to crimes against humanity.
I know two parts of an answer to your question. I've lost my mic. Sorry, I'll just refix it. And one is just to do with seriousness. So you ask what would justify wheeling in the whole apparatus of international criminal law? Well, that's something pretty serious, making it worth mobilising at all. But then the other answer is, which I tried to wave at in the paper, that in all kinds of ways, states cannot do their job very well, including investigating individual crimes. But where you've got crimes against humanity as defined in the statute, i.e. crimes which are part of an attack upon a civilian population, an attack on a whole group, either a whole civilian population or a group within the population. In that context, it seems to me, then the state is more drastically complicit in the crime, either by instigating it by its own officials or in a failure to investigate it seriously. Then it thereby condones the attack and thereby portrays that population as being attacked as not worthy of its protection. So I think it does make a difference, the nature of the state's own failing, dealing with that kind of crime with a collective target. And that gives us, the international community, more standing to say, look, it's not just the state is not doing its job very well. The state is now betraying its own people by being complicit in this attack on a whole group. And that's a way to explain why its brief is limited in that way to attack crimes that are parts of attacks on a population. And okay, your account is still a tempting one. And my ex-colleague Massimo Renzo has this story. He says, look, crimes against humanity include any crime which denies the person's humanity. So any murder, any rape is a crime against humanity, with just an individual victim. That's his story. Okay, most often these are dealt with most effectively, most efficiently by the local state. But where that fails, then in principle there's room for the international tribunal to intervene. And that sounds like, quite like your story.
That does sound like my story, and that way you can explain both the complementarity feature of this court, but you can also explain the limited brief. Because otherwise, if it's just merely a proxy, why is its brief limited? I guess is my key thought. If it's just a proxy for failings of the criminal proceedings at the domestic level, why the limited brief?
Because I'm suggesting others have the right to intervene, not just when the state is failing, but when the state is itself complicit in the crimes, in the way I tried to describe. But anyway, as I say, your story is an attractive one. It makes it much simpler. And I would accept it, well, I would be more inclined to accept it if I could believe in this notion of humanity as a political community to which individuals belong as individuals. Because okay, the notion of humanity as a moral community has some traction. In aspiration, we'd like to see ourselves, morally speaking, not just as members of this or that smaller group, but also as human beings. But I recognise our fellow human beings as having a claim on us simply as human beings. And that's cashed out in all kinds of ways, including in an international body.
Right.
So in terms of moral community, you see the aspiration to see humanity as a community, to which then I might answer morally for what I do.
Sure.
But criminal law requires, as I said, a political community.
Yeah.
And I still can't see in the international sphere a political community to which we as individuals belong.
Sure.
That's what my problem with accepting your kind of argument.
Sure. Let me just say this one, and then I'll just kind of leave off. But one way to think about it might be just the creation and the fact that the ICC is going is an ongoing concern. You could maybe take that as an assertion, an incipient assertion of a political community of that sort, which might begin to actually generate that sort of community.
And I used to believe that. I keep changing my mind on this. Maybe next year I'll believe it again. But I used to believe that we should see the ICC as part of an attempt to build a community which we'll then be a part of.
Yeah.
And I think that kind of story, that kind of argument, that we see institutions, we see as trying to build up the communities upon which they then depend, and that does have a lot of traction to it. But I think there's only more in place, I think, than we've got yet to see the ICC in quite those terms. There's not enough here yet in the way of political structure to see that's what's going on. So again, I'd love to be able to tell that story, but I can't quite yet believe it.
Thank you.
Professor Farmer, and then
Well, there are actually 3 mics, aren't there? There's one here as well. So.
Yeah, it's on.
Okay, well, I have a couple of thoughts. One was just a thought as to how we might address the kind of points that were raised by both Michael and François about the practical problems associated with trials. And the thought here is that actually it's important to hold onto this as a way of understanding the limits of holding political trials in these circumstances. And I think very often, politically, the demand is in these types of transitional situations that there be, we should put the offenders on trial, as though that's, that's going to be then the, therapeutic in some way. It's going to be the forum for the victims to have their voice, and it's going to, the trial is all singing, all dancing. It's going to do all of these things, and so that it's important to understand the limits of what a trial can do. So, I mean, a stronger version of saying, well, there are these problems, is just saying, there are these problems, and that, in certain cases, this, we shouldn't overburden what might be expected of a trial in these types of situations. The second thought was just on, and this is perhaps less surprising, actually, on the retroactivity point. Your answer to Michael on this, where you said, well, this, the way of dealing with retroactivity is the idea that there are pre-existing public wrongs, some of which are then recognised as public wrongs for which one can be called to account. And then you give the examples are murder, rape, assault, torture. Okay, and that's very easy, all right? And because some of the relevant wrongs might be things like transferring funds out of the country, political leaders who've done things like that. So that we can see these as wrongs in a certain way, but without necessarily seeing them as the kind of mala in se in that you're characterising here. So the thought is this: given your answer to the former question about the continuity of political community, in that there is some sense of continuity that in the transitional situation, but the whole idea of transition is saying that we are the same community, we're reconstituting ourselves in some way, we're responding to this. Could there be some mileage in answering the question of retroactivity? So that the idea of wrong could be that the sense of an idea of those kind of acts would have been a public wrong against our broader sense of moral political community as something which is continuing, and that wouldn't necessarily have to rely on the mal and say that sort of sense. It would perhaps be a broader notion of a continuity of wrong. These were things that we recognise as wrongs, that we, the broader political community, recognised as wrongs at the time, but the particular body that held power didn't recognise these things as wrongs or abused the law in some way. So we're appealing to that broader sense. So it's just a thought, but it might be one way of an alternative way out of the retroactivity conundrum.
Thank you, yes, for both those. I agree, it's important to emphasise, this is on your first point, which I didn't, the limited role trials can possibly play in this kind of context. I think what I wanted to do, and I'm now clearer than I was then, is, again, just to detach trials from punishments. And again, what matters? What could properly matter in the transition from conflict towards peace? And you think back towards the past wrongs and how they can be addressed. And I would resist the thought that they were addressed as wrongs only by trying to punish those who committed them. And say, no, that's not the only thing that matters. What also matters, what's also a value, is a process according to account. And this is a value in the guise I tried to describe. And I think that's the most I want to claim. And you're right, there are limits both on the conditions under which trials are even possible, and also limits on what we can expect them to achieve. And to say trials are the way forward is absurd. So you're right, I should make clear about it that trials can play a role within the process, but a rather tightly cabined role as to what they can, and the more you try to make them do, the more dangerous it is that they'll do harm. But then there is this further thought, which ties in, I think, part of what you said, and also some of the other comments, that in the context of ordinary domestic criminal law in a stable context, there are all kinds of limits on what the trial is meant to deal with. In particular, the trial takes for granted, actually this also touching on the second point, takes for granted, here's what the law is, here's what the offence consists in. Okay, there's some room for interpretation around edges, but roughly we take for granted the law, and the trial is, are you guilty of that offence as defined? If the defendant wants to argue about the law and say, but that shouldn't be criminal, the answer is, well, this isn't the forum to do that. This is the trial. The forum for arguing about what the law should be is the political forum outside the courtroom. Likewise, if they want to discuss the further motivations, other kinds of relationship which are involved, again, that's not part of the courtroom process, that belongs outside the courtroom in informal processes. So in ordinary domestic criminal law, the trial is a very, very tightly defined, limited forum in which only certain issues are up for discussion. In particular, issues about the legitimacy and of the law and whether they should be criminal. And that kind of limitation makes sense if we can say, first of all, the law is fairly well fixed. And secondly, there are other fora available to you in which you can pursue these further questions about what should be the law and so on. If we can't say those things, then the trial ceases to be, whether the trial limits itself ceases to be justifiable. So one question, whether you then switch to the context of transitional justice, whether we can say there too that the law is, the law bearing in mind the law is applied to what you did 10 years ago, is relatively stable and fixed and can be taken for granted by the trial. And further dimensions of the wrong, including its further context, also the way in which it involved collective agents and so on, can be separated out from the trial and said, well, those dealt with elsewhere. Maybe it's harder in the context of TJ to make that kind of abstraction from the conduct itself, to say, let's pick out this agent and this clearly defined wrong and say that's what the trial focuses on. The rest is dealt with elsewhere. If you can't make that kind of abstraction plausible, then, well, either they need to revise the notion of the trial to allow more come into the trial process in this context, or trials that cease to be possible. And perhaps in particular, and this ties into the point about retroactivity, as I say, in an ordinary domestic trial, if I try to say, look, I admit as the law now stands, I'm guilty of the crime, but that shouldn't be the law, and I want to argue in court that that shouldn't be the law, and say to the court, the law itself is unjustified, and therefore they should acquit me. That's not going to be, at least legally speaking, heard. In fact, you might get the jury to nullify if you get the jury to hear what you're saying, but formally speaking, what you don't do in court is challenge the law itself. You're told that, yeah, that's a matter for political debate outside the court. You might think that if there is an issue in the context of transitional justice about the legitimacy of the law under which you're now being tried, there needs to be a forum in which you can argue that out. And maybe that needs to be argued out in the courtroom rather than somewhere else. I'm not sure about this, but you imagine ways of expanding what the trial deals with in this particular context. Then on your second point, which this brings on to, I didn't, I hope now, mean just to say, look, Marler and say, okay, that's it, that settles it. What matters is that the court can now say that even if what you did at the time, well, now what are we talking about? One case where it wasn't, in terms of the explicit statutory law at the time, criminal. Another is it wasn't treated as criminal by the state's officials. It was condoned or accepted as what happens. So there are different possibilities here. But the court must be able to say that, I think, two things, one of which at least you deal with rather nicely, that what you did was at the time not just a wrong in some abstract sense of wrong, but a wrong in terms of the very values of the political community we're now trying to reconstitute. And this was really your suggestion. I think that's very helpful. So looking back at what we can now say the community was, again, in aspiration, not actually in officially enacted fact. Look, understand what the community was, and can't you see how that conduct was, in that context, a serious wrong in terms of the community's own values? And if we can say that, then that gets over the issue about retroactivity. As long as we can also say, secondly, and it must have been evident to you, if you had thought about it at all, you must have recognized that. So you can't now say, gosh, I never knew. Thank you. That's a very helpful way of approaching it, though, to ask, again, how we can now interpret the values of the political community, which in some sense existed then, although it was in various ways distorted and not being enacted. I need to talk to you more about that afterwards and get some plagiarizing.
A question here.
So I'm a little hesitant to ask this, just because I wasn't able to make it to your talk yesterday, so I hope there wasn't my intellectual doppelganger or something already asked this question, so it's shoo me away. I'm just curious about the kind of communicative approach that you're characterizing trials with, and the kind of importance of engaging with perpetrators, because it strikes me that this rests on an analogy between domestic trials and these international trials. And in these cases, in international trials, especially with crimes against humanity and these kind of really heinous acts, take Nazi Germany, for example, you have perpetrators who are rarely going to be in a position again to commit their crimes. So it seems that we might maybe be a little bit more favorable to the kind of expressive approach that Luden takes, because you have maybe more like a static role of victims, that they're always citizens. They kind of have a more static place in political communities, where perpetrators, it seems like more of a one-off situation. I'm just wondering what your thoughts are.
I'm not sure yet quite see what the issue is.
Well,
why communication is more dubious, where the perpetrators won't have the chance to.
Well, yeah, I mean, if we're trying to focus on engagement with perpetrators, it seems that, victims getting a chance, or taking the primary aim to be engagement with victims, that should be the one-way kind of expressive approach. It seems to kind of do justice to that without really placing a lot of emphasis on engagement with perpetrators, which is what I take your characterization to be doing.
I think what you say would be right if the point of the engagement with the perpetrators was simply to prevent them repeating their offences. I don't think that's the only or perhaps even the primary point. I guess the thought is this: in this way, I want to insist that perpetrators are treated as members of the community. It matters that we get the person to confront what they have done. We try to get them to recognise what they have done and to answer for it. And that matters not just because that will then have an effect on their future conduct, but because that's what it is to take them seriously as a moral agent. So an engagement with the perpetrator matters whether or not they're going to have a chance to repeat their offence. It matters both for the victim and also for the wrongdoers themselves, that they are called to account for what they have done. So I don't buy the thought that communication is worthwhile only if it's going to have some future effect on future conduct. I mean, its value is independent of that. And even the person will never get the chance to do it again, come what may, it's still worth engaging with them. Otherwise, just say, look, what are you saying otherwise? Just you are no longer important. You no longer count as a moral agent.
Professor Brudner, the microphone disappeared somehow. Is it?
Yeah, this one's acting up, so I can use that.
Okay, so I'll just pass this one on. Get back to me afterwards. Thanks.
Thanks, Anthony.
Keep it.
So two thoughts. One has to do with your understanding of criminal trials as such, and the other with how that understanding might apply to supranational contexts. So I've actually always had a problem with the idea that trials have to be separate or dissociated from punishment, and that the idea of the trial is to call the person to account. It seems that might be inconsistent with the idea of the presumption of innocence, and also doesn't capture what actually goes on. I mean, is it the case that the accused has to account? It seems to me that the accused doesn't have to do anything, doesn't have to say anything. Rather, it's the state or the community that has to justify its accusation to the accused. right? The accused has to be there. So there's a communicative aspect for sure. But I wonder if you haven't got it backwards, that it's not the accused who has to answer to account to the community. It's the community that has to do the justifying to the accused. So that's one thing. Now, to the another thing that bothers me is that in saying that the accused has to account to the community, there might be a collapsing of the public nature of the trial into, well, into a contest between particulars, that is, the accused and the particular community. So it's more like a private action than a criminal action. Now, in the domestic context, where there are adversaries, so it's accused against the community, but in the domestic context, there's always a third person, right? The judge is the third person mediating between the community that has been offended and the accused. And when the judge takes the position of the community in sentencing, there's the third person of the jury between the judge and the accused. There's always the third person in the domestic context. But now, in the international context, where is the third person? So if Eichmann is tried in Israel, where is the third person? That lends legitimacy to the ultimate verdict. It seems to me that that's one problem with characterizing the trial as a requirement that the accused account to the community, right? That there's and the particular problem of supranational justice, that this lack of a third person.
Right, thank you. I don't mean to describe what goes on in our courtrooms. That doesn't bear much description. I do want to say, though, that while it's true that the polity or the state has to justify itself to the accused, I say this is a two-way process. So I want to say it's a calling to account. It's not a coercing to account. The accused isn't coerced into saying anything at all, you point out, but you can call without coercing. So you think why it matters, if it does matter, that the accused enters a plea at all, not guilty, not guilty. That's like an answer, not yet for anything, but an answer to the charge. And then, so it's proved that, yes, like you did kill the person, then they say, yeah, yes, but it was self-defense. I explained myself publicly. And it seems to me, except for this point, that there is, even where it's clear, suppose it's clear to those who investigate the killing that it was self-defense. Obviously it was self-defense. There is, seems to me, a reason, a good reason, I don't say conclusive, a good reason to prosecute. It matters then that the accused in public answers what they've done. Yes, I killed him, but it was in self-defense. And that's an important transaction, if you like, which has value, as I explain myself to the community what I have done. So I want to insist that the process here of being called to answer to a charge and for my conduct. It's true that the presumption of innocence protects me against being convicted until there's proof that I'm guilty. It's also true that I'm not required to play any part. I'm not even required to enter a plea. If I don't enter a plea, then one's entered for me. So I think there are ways in which we protect the accused from various kinds of coercion, various kinds of possible oppression, by saying, look, you are called but not required to take part. So I still think it seems to me a way to understand the trial and to understand why it matters that the accused is given this role is if he's a calling to account, which isn't yet enforced coercively. But, which comes on to your next point, I'm not clear about the judge as third person. It seems to me that the various officials concerned are speaking in the name of, well, the community here is not so very local community, the community is the political community as a whole, the polity, in whose name the person is called to answer. So I don't see why you are answering through the court to the polity, why you want this third person in play. The judge is speaking for the polity, to my answer, and who will judge me through these officials. I'm not clear why we need a third person.
Well, I think the judge stands between the state as a party to the criminal trial and the accused. It's precisely because they're adversaries that the judge sits as third person. And when the judge takes the role of the state in sentencing, it's the jury that gives, usually that gives the verdict. So that there seems to be that mediating element in a trial that's absent in the case of supranational in the supranational context. You don't see the judges exercising this mediating role between adversaries and
The prosecutor in an adversarial trial. The prosecutor has a distinctive role as putting the case against the accused. In that context, the judge then certainly is the third party between prosecutor and defendant. But I think in the end, though, the court is speaking, the prosecutor then is speaking, taking a particular role within the structure. Still, the court, in the person of the judge, is speaking for the community. And it's to the community, not the prosecutor. To the community I answer for what I have done, not to the prosecutor. So I sort of say that there is, within the trial itself, you've got the prosecutor, defense, judge. The judge is the third party between those two competing parties. But still, it's a third party who is acting on behalf, in the name of the community. And the prosecutor has a limited role, which isn't like the role of speaking for the community. So I still don't see we need the judge as a third party between community and, if you understand community as the polity, not as a smaller group who might have very strong feelings, but as the polity whose law is being here applied and enacted.
Professor Davis, if you can.
Yeah, I've been thinking about this idea of the criminal trial as a way of community building, if you like, or strengthening senses of community in populations. And I'm thinking it isn't so much the ordinary domestic criminal trial that's the model. It's more so the trials that take place in more extreme situations like insurrections or civil war, and that it wouldn't be hard to extend that to the transitional situations involving the international community. And occupied territories, where, following an insurrection, there's no shortage of guilty people, but the trial is a part of it. But the judicious use of the pardon and the commutation of sentence is a much bigger part of the picture, because the goal is really community building. You want to identify quickly those who are reconcilable and reconcile with those as quickly as possible. Maybe have a few. Maybe making an example of a few people who are clearly irreconcilable, and for the most part be forward thinking. The vast majority of people, give them a trial period, and if they're gonna be irreconcilable, they'll identify themselves soon enough, and you'll deal with them in a situation that's much more stable. There's probably a reason why Napoleon was exiled to St. Helena, and historically, I think you'd have to say that the failure to commute Louis Riel's sentence was a big mistake.
Anyway, this comes back to part of Lindsay's point, that the role trials can play in reconstruction is a very limited role. And trials are a kind of symbolic enactment of reconciliation and reconstruction. They enact a situation in which there's a defendant who is treated and addressed as a member of the polity, which the victims come forward as his fellow members, and so on. It's a kind of enactment. And enactments have a symbolic importance, but they can achieve anything only if they can presuppose a whole lot going on outside the trial, which will allow people to take the enactment seriously as something other than a farce or something other than an oppression to be resisted. So anyway, the point is this, that trials of the ordinary trials of the kind that we are familiar with in domestic context, trials with those kinds of limitation on what they try and do, can play an important symbolic role in transition from conflict to peace. But like every kind of symbol, that role can be played only if there's a lot of material work being done outside the trial, which you can rely on. And I'm sure you're right that if now when can trials actually, when can that symbolism actually have any impact, have any real significance? the answer isn't going to be uniform, either between different contexts or within any context between different possible kinds of trial. So they can be used only selectively in various ways. That seems right.
Professor Chow.
Anthony, I want to follow up, I think, on Alan's first point, which goes to this, the way you think about trials generally, I think. So you said you want to look at the value that trials have other than as a means to punishment. And that seems totally fine in that, of course, trials can be a means to punishment, and perhaps they have other values as well. But once you get into particularly the transitional and international contexts where it seems like it's really just the trial that we're talking about or that we're primarily interested in, then I wonder why focus on, why take the ordinary criminal trial as a model at all? Because after all, it does seem in the domestic context, the fact that it is a means to punishment, perhaps among other things, but that it is a means to punishment is quite crucial in our understanding of what it is to be a criminal trial. And what the procedural and substantive form of it takes. So I think this has come up in a number of contexts in the retroactivity point. So for instance, do you have a right against retroactive application of the law? Well, no, not really, except in criminal trials. Outside criminal trials, we apply the law retroactively all the time, all day long. It's only when it's a particular type of consequence that's at issue, then you say, oh, now we really care about retroactivity, about notice, and so forth. Similarly, for the beyond a reasonable doubt standard, that seems to, at least historically, be based on some idea of this Blackstone ratio, which again seems to be tied to the idea of the consequence, what happens to you at the end of if you come out in the wrong end of a criminal trial, or the role of defense counsel. Again, you might have defense counsel in a more communicative trial at which no punishment was at stake. You might have defense counsel, but they might have a very different role than they do in anything like what we see now in ordinary trials, or the role of appellate review might also be different if you think of it. So this is just by way of saying, well, if you think about the criminal trial, if you think about trials where punishment is just not on the table at all, right? Why even? Maybe we could have some other type of ritualistic, communicative endeavor that would achieve all the goods that you identify, which I agree sound like quite valuable and important ones, but which would bear only a very passing resemblance, if any, to what we call a criminal trial.
Well, it depends on how important you think it is to be essentially condemned as a wrongdoer, because a trial, even without punishment, a trial ends if you're guilty with a conviction, which declares of you that you committed this wrong. You're censured by it. That's quite a big deal. If you think that matters, then you'll see reason to build in the kinds of protection which you're talking about, even if no further punishment's at stake. And being convicted itself is a kind of punishment, isn't it? And you shouldn't downplay the importance of convictions, even apart from their role as prelude to punishment. Of course, you're right, and I haven't anything more about this, that I guess I was thinking about trials, not trials without punishment, but what trials could mean other than a means of punishment. I'm not saying there wouldn't be punishments to follow, but even ignoring those, what value is there in trials? It's certainly worth asking, as you point out, how far various procedural rules depend for their justification on the prospect of punishment, and how many depend only on the prospect of conviction. I'm trying to think still that even if there was no punishment in prospect, we should still presume innocence, we should still convict only on proof beyond reasonable doubt of guilt, because before you condemn someone as a wrongdoer, you should be damn well sure on good grounds they're guilty. So the conviction is a formal condemnation, then that should be based upon proof beyond reasonable doubt. I want to build in a whole lot, at least many of the obvious constraints on the trial, even if the outcome is only conviction rather than some further punishment. Did you want to come back?
We can talk more about it.
You want to come back?
Okay. No. I'm happy to pass the mic.
Okay.
Thank you. I have just a small question about, you said here and you've said elsewhere about how the trial is not the proper forum to ask after the legitimacy or the morality of the law that's being applied. It's just there to apply it. And you argue that for a criminal trial system like our own, there needs to be the existence and then the separation between some political institution involved with making and changing laws and then the trial itself in applying laws. This is so to obligate individuals to obey the law. But given that an individual perhaps hasn't met that obligation and hence have their day in court, why isn't the trial a more reflexive enterprise? And why isn't the courtroom the proper forum for testing the legitimacy of the law? Because it seems like if the trial is a justificatory enterprise, then wouldn't it be the best way to justify something as to have it be a reflexive sort of enterprise?
And the main problem is this: that if you allowed the trial court to deal with the question of whether this law is justified or not, and to acquit the defendant if this particular court thought the law was unjustified, that's in effect to make the law changeable by a particular judge or a particular jury. Actually, 12 people or one person can change the law, and that doesn't seem appropriate in democracy. So you imagine two defendants, each of whom objects to the law they're being tried under. Same law, same charge, in different courts. On your system, each of them can argue before the court, this law should be repealed. One persuades the court, gives them a particular political makeup of the jury or whatever, the other doesn't. One's convicted, one isn't. That doesn't seem appropriate. So what underpins the thought we should have this separation of roles is all about what it is to make law democratically.
Although it seems like then that someone's made the wrong decision in each case. Like one of those people had to, like either way, if it was the law stays the same, it seems that someone's making a mistake, right? In that scenario.
Mm-hmm. So,
well, that we don't want that to happen either, do we?
But
well, I guess what I'm saying is that if the law stays static, but perhaps it should have been that one person wasn't convicted, but because they don't have the forum to change the law, like what is the mechanism then? It's just it's an appeal, it's trying to change the law at a later date at that point?
Now what the court needs to say with a straight face to the defendant is, look, if you object to this law, then there's the forum in which you can argue your case, the political forum. And it must be true that the defendant has access to that political forum to argue their case. If that's not true, then that undermines the court's own legitimacy. If it can be said in a clear face, then the court can say, look, here's how the law gets changed. Meanwhile, then your obligation is to accept the law. And then there are further complications about what we say to defendants who are conscientious dissenters. In what terms the law should speak to them. I think there's further more to be said there. Sometimes what the law should be saying is, look, we recognize that you dissent, and your dissent isn't manifestly unreasonable, but still it's a dissent from what the law is. You owe it as a matter of respect to your fellows to obey the law, unless and until you can get it changed. So I think it matters that the court can say that and it be true, that there is another forum to pursue the debate.
Dr. Phillips.
Just a quick question about how there might be a structural problem with using trials at the international level. It seems to me that reconciliation between two people is going to require something particular about them in order to be effective. And one of the things that a trial tries to do is actually depersonalize that and make a uniform and consistent justice across the board. So what a trial does is it actually uses standard procedures to ensure that whatever justice is done between the parties in that case will be applicable in future cases in a consistent and coherent way. The problem with that is it ends up then leading to an injustice between the parties in the individual case because they're asked to use a standard form. It's basically like a Hallmark card they give to each other as an apology at the end of the day. It's got a standard form, it's expressed in the same language, and they're trapped by the procedures of the court. They have to use those. That way they guarantee consistency and coherence outside of those two parties. So it seems to me there's a structural problem that develops between the goal of reconciliation and the goal of coherence. The trial seems to me apt for coherence, but it doesn't seem very good at reconciliation. And so I kind of imagine, I'm trying to imagine anyways, what your vision for the ICC would be with, for instance, let's take Aboriginal people in Canada who tend not to recognize Canadian common law courts as really speaking to their concerns and their need for reconciliation amongst the community. And so what they'll say is that a trial in a common law court isn't going to appropriately reconcile them to one another. And so is that now that at the ICC level, the trial should change to reflect how an Aboriginal would basically engage in reconciling with their own community, or do we impose that standard form at the ICC level of what a trial is in all cases? So if there's localized legal systems that have particular ways of doing reconciliation, the ICC should try to adopt those. Or is your thought that there should be a uniform trial system put in place at the ICC with the same procedures in all cases? So I'm just trying to see what your vision is for this, and then how you would try to answer that structural problem that I think exists.
I think that just because on my account the ICC serves only a kind of proxy role, the ICC is not apt to the task of reconciliation. It's not speaking from within the community within which that must take place. I think the ICC isn't in the business of reconciliation. But the larger point you make is about trials in general as reconciliation. So let's talk about domestic trials. You're right, okay, so there in the courts you've got an individual defendant, an individual victim or victims in victimizing crimes, have all kinds of personal trait, all kinds of personal concern, all kinds of maybe personal dealings outside the trial. Maybe they're neighbors or colleagues or whatever outside the courtroom. And right, the court takes a highly abstracted view of what goes on. It says, here's the offence definition. Did your conduct fit that definition of an offence or not? That's all there is to it. So it's a highly formal, ritualized, abstracted process. It's not apt to reconcile you as friends, as neighbors, as lovers, whatever. But that's not the criminal law's business. It's a highly formal process of dealing with you as citizens. And the outcome is a formal and really ritualized reconciliation as citizens. There's no more than that. And citizenship is a fairly abstract relationship. So you're reading more into reconciliation than I want to read into the trial. It's a very highly formal, ritualized process. And you get the hallmark card, and that is the end of the process, as far as the law is concerned. And we expect you then to treat each other thereafter as fellow citizens.
Right. My question is actually more towards the idea that you think of the reconciliation as between the individual polities involved. And so my thought is that the standard form won't work for the individual polities involved. The ICC is, in a certain sense, trying to take on that reconciliatory role within the polity. So yeah, I know I can grant that in the domestic system, you're going to try to reconcile with larger citizenship. But the point is that there's a particular type of understanding of law and trial process in each one of those individual states and in each of the individual polities, which will make certain forms of trial legitimate and certain forms of trial not legitimate, certain processes in a trial. For instance, I think it came up yesterday, the adversarial system may not be recognized as legitimate within certain polities. They think that that's wrong, that the judge should be participating in this, shouldn't be adversarial between parties. I mean, this is one of the issues with the Aboriginal systems in Canada is they don't recognize this adversarial system as a good way to do a trial. And so that's really what my issues are coming from. It's the idea that within these individual polities, they have their own conceptions of how to reconcile the citizens with one another. So it's not just purely the two individuals involved, but even the reconciliation with the larger citizenship takes on this overlay of culture and individuality or individual polity norms.
Okay, sorry, I misunderstood you initially. Right. Okay, so then put it crudely, the question is this. If the ICC is claiming to, in some sense, speak as proxy for or speak for a local polity, how far should it then, on the one hand, sensibly apply that own polity's way of dealing with criminal trials? Or how far should it insist on imposing a uniform process across? Is this the issue?
Right.
And both you think are problematic.
Right.
To some degree, I said to some, that's a matter of negotiation in the creation of an ICC. How far can the signatories to the treaty agree on a procedure as one they can all recognise as legitimate? If they can, then that deals with your issue. We've got an agreed procedure which reflects acceptance by all those whose case will then be heard at the ICC. The issue becomes more crucial, more difficult when you have the ICC trying cases from policies which are not themselves signatories to the treaty or don't feel that their voice was heard in the way the courts are structured. then there are two possibilities, three possibilities. One is to say, right, the ICC must simply go local, it must take on board the local procedures. And you might think that's not, but the question is still, though, which gets us on to the second and third possibilities, it can't just take on board local procedures without question, as it were. You might say, look, let's allow the ICC to various procedures insofar as they're reasonable local variations, and the ICC recognises those. You know, then how do you define what is reasonable, and we're back to the issue. One suggestion you made yesterday can reappear here, that insofar as we can say, look, given what you say about yourselves, I understand yourselves as being e.g. democratic or as being so justice as that's understood, these procedures instantiate that. If that can be said, then that's the way forward. If that can't be said, if we can't in that way appeal to what's already available in how the polity portrays itself, then it seems to me we face a familiar kind of crunch. Does the ICC say, right, well, we can't now say anything because we have to respect difference and leave you to do your own thing? Or can we insist and say, look, we the Community of Nations, insist that justice requires this, and if that's not your way, then you're simply wrong. And when and how can that be said? And this is what I'd like to finish with about all kinds of intervention, how far the other nations can insist, not just on holding a nation true to its own declared values, but insist on saying that you're simply wrong. I don't have a clear answer to that.
Dr. Grillet.
I'd like to follow up on the point that was made over here. And I think I'd like to ask your opinion about a way to resist it and maybe the implications of this way of resisting this thought. I too was struck by the idea that this part of the power of this paper is its kind of ritualistic portrayal of the court and the power that that can have in community building and in community reinforcement. I worry about the idea that we could, I'm not sure about the idea that the benefits of the ritual of court practice, the trial process, could be duplicated in another setting. And I wonder what your thoughts are, and then I'm going to suggest that, I'm going to offer the suggestion, ask for your thoughts, and then especially on the connection between the trial and punishment. Because I wonder if punishment might actually be called for, given your line of reasoning. So the suggestion would be like this: the thing that distinguishes the criminal trial, the thing that makes it uniquely important in a transitional setting, is that it represents that most important stage of a citizen's relationship with its community and vice versa, which is where they really come, it's an adversarial one. They come head to head. And what makes the trial so important, and what makes the expression of a just trial so important, is it reveals the state's position, it reveals the state's procedures. Is this a just state? Are they responding to the community's conception of justice? I mean, this to me seems to underpin the idea that what symbolically or intrinsically is valuable about the court is the demonstration of its authority over its citizens. It recognizes the victims. It recognizes the moral standing of the individual in trial. Given this uniquely important setting, I think it is uniquely important, I wonder if it's enough to say, well, we can just talk about the trial and its intrinsic good. And I think you can do that in the abstract, but I wonder if the logic of this unique setting would suggest that it's actually important for trials and transitional communities to involve a sentencing. Because the sentencing, too, is a place where we demonstrate the authority. It's the place where normative and de facto authority meet. It's where we recognize the victims most acutely. We sentence somebody to punishment in under a great many conceptions of justified punishment as a way of respecting the victim, right? Be that an individual or the community as a whole. And of course, it recognizes the moral standing of the individual on trial as a moral agent culpable for their crimes. So I wonder if the symbolic, the intrinsic value of the trial actually suggests that there ought to be punishments attached in transitional settings, just given the logic of your position.
I actually wouldn't be that unhappy if that was the logic of it. I guess I was trying to avoid partly taking a stand on the aims and purposes of punishment. As for this paper, I have my own views on that, but I know you get different answers from different kinds of punishment, whether and if so why punishment is also required if you have a trial process. But I think in terms of my own view of punishment, I think you're probably right that the way to address the wrong seriously, as the kind of wrong it was, the way to address the wrongdoer seriously, would include not just the process of trial and conviction, but also then a further process of sentencing and saying, here's how you must understand the wrong you've done, and here's how you can make reparation for it, and so on. So I agree, in terms of my own view of punishment, and others would have different views, then there is a proper progression from trial through conviction to sentencing to some kind of punishment. If that's right, then to say we might have trials without punishments is to say we're still going to get at best incomplete justice for the wrongs. But still, there's still a kind of justice being done. That's what I want to emphasize. It's still the very fact the person is called to account, especially if they actually do then answer what they've done in a trial. That by itself, without further punishment, does instantiate an important value. So I agree, okay, the value itself then would naturally be completed by punishment. But even if that's not feasible, if we see reason not to stop there, then there's still something important being achieved. So I don't want to say punishment isn't important, or it doesn't matter. But I'm saying that here's what trials can be and what the goods they can substantiate, even if they don't lead to punishment. And I can still say that even if I agree with you that the not leading to punishment is not just, well, they happen to stop there, but is itself a kind of incompletion, a kind of stopping short of where they properly tend.
If I can just add one thing to that, I would also wonder whether, I mean, there was a suggestion in which you said in response that, well, on your conception of punishment, but if we don't worry about particular conceptions of punishment in and of their own right, and we think more about the intrinsic value behind the trial, I think you can think of punishment as being justified, especially by those intrinsic considerations, irrespective of the actual punishment meted out. And here's why. You say, one of the important things about the criminal trial is that it expresses a certain political perspective on which, let's say, batch of wrongs we're going to criminalize. Right? But in just the same way, right, the act of punishment, the punishments we select amongst the wide variety of ones we might, given a reasonable conception at least, of justifiable punishment, that too expresses something about the relationship between a government and its community. So I would think that all other considerations of justified punishment aside, this gives us a reason to punish, if nothing else, just to see whether they live up to the aspirations that they purport. How do they implement or operationalize the conception of punishment that's promulgated in these new transitioning communities? So I would think that there's value there even outside of the normal kind of considerations of justified punishment.
I was thinking, if you see punishment as essentially a matter of deterrence, that gives you of cost-effective deterrence. There must be an open question whether, in this or that context of transitional justice, whether you need punishment or find punishment useful in that context. Maybe you wouldn't, I don't know. I think it's a contingent question now, whether punishment can be a cost-effective means of securing goods in that particular context, or whether you're better off not having punishments attached. That's all I meant.
Yeah, okay. I guess I was suggesting that and maybe I should detach this from the act of punishment itself, but say that the act of sentencing is revelatory. It exposes, it realizes, reifies this new state in this most important context, at the most important moment maybe. So thank you very much.
Certainly, okay, what's true is that if we preserve a system in which normally punishment follows conviction, we preserve that aspect of ordinary criminal law, and when they have these particular trials in the context of transitional justice, then we say, of course, these trials don't bring punishments, although the crimes involved are enormously serious crimes. There's something attention there, certainly. Is that part of your concern? So at least, and part of the point about punishment too is it helps to mark just how the offence is understood in terms of e.g. its seriousness. So you're convicted, and the conviction brings with it a fine of $100 or prison for 5 years. That marks a difference in how we understand the crime. So that we're missing. So I can see, is that getting closer to your point?
Yeah.
Yeah. Okay, in a context in which normal trials result in sentencing and then in punishment. Trials which didn't have that kind of, those stages would be incomplete. And maybe then, we say, you imagine sentencing, so the court would say, here you're convicted and your sentence would properly be this, but we suspend it, we give you an amnesty or a pardon.
Yeah.
Would that be?
Yeah, that's what I'm thinking about. That's just
yeah.
such an integral element to the intrinsic values it adds to them.
Yes, thank you.
So we have time for one last question. Any takers? If not, I would ask you to join me in thanking Professor Duff for a very thought-provoking 2 days. Thank you.
Thank you.